thank you, Charlotte, for that kind introduction. The first thing I always want to do is make sure you can hear me okay. Is there anybody here who cannot hear me? Great. Our cameraman, Tom, is joking. He can't. Thank you, Tom, for taping this for the viewers at home. I know we have air conditioning and some noises, so if you need me to repeat anything, just raise your hand. As Charlotte mentioned, I'm a certified elder law attorney. That's not a degree you can buy on the internet. It requires years of focused study. It requires a full-day bar-style exam. And there's very few of us who have made it through that process to receive that designation. And it designates us as experts in the field of estate planning and elder law. And today we're going to speak about protecting your family and your assets, legal strategies to implement now. And this is a very timely topic, given the state of the economy, all of the uncertainty that we have. People are thinking more and more about what they've saved and how to make sure that it's there for them in the long term and how to make sure they're not going to lose it, depending on how their lives unfold. And so I have many clients who are very concerned about this, and I'm certain that many of you are concerned. When I look out in this room, I notice that many of you are what we might describe as seniors, at least according to the state of Massachusetts. Depending on the age, it's a number of different measures, but anybody over 62 is they count as a senior for certain things. And there's a few folks who are under that. But seniors, it's not a surprise, are perhaps most concerned about issues of protecting family and what they've saved, just because they're at that stage of their life where they may have a house and savings, and they're at that stage in their life where they're more concerned about their health and things that could potentially occur in their lives. As many of you know, there's a lot of folks who have no protection whatsoever. I had a client recently, an elderly woman who had grown up in the Depression era and had been very fastidious about how she spent money during her lifetime. She saved very carefully and lived that life for many, many decades. And a couple of years ago, she had a health crisis and ended up in a nursing home and ended up spending down all of her money on nursing home care. And the son had actually come to me. I wasn't involved before, and told me this story and how traumatic it had been for his mom to be in that position. And so we know there's a great need for protection. The key is timing and making it happen. I'll start also by asking, what's the difference between folks who get themselves protected, get their family and their assets protected, and many folks who don't get themselves protected? And in my years and years of experience and practice, I've found that it boils down to three key words. Those who are protected seek out expertise, action, and investment. Expertise, action, and investment. And those are really the three key words that can help lead to you becoming protected or your family. Now, expertise, you want to work with a lawyer who's an expert in the fields of elder law and estate planning. And one of the handouts I've shared with you today is 10 questions to help you locate a qualified elder law and estate planning and attorney. And I have that handout as well on my website, curleylawfirm.com. And you want to make sure that you can ask an attorney you're working with those questions and that they will give you a confident yes to each question. You want to be sure that they're practicing this area every day. The second word is action. You have to take action. And what I find is that it's very easy to procrastinate. We're all natural procrastinators. It's very easy to delay. Sometimes these issues are daunting, scary, uncomfortable. But the only way to really become protected is to take action. The last word is investment. You have to make an investment in yourself and your family to become protected. A simple will or a plan that you might get off the internet is not going to protect you. And so you must be willing to invest in your future, because that investment is going to pay off many, many times over for you, your family, in the future. So So I want to start by talking again about this idea of protection. What is it that we're trying to protect against? We can't protect unless we know what our concerns are. So I'm going to ask you in the audience, does anybody have ideas? What is it we're trying to protect our family and what we've saved against? Well, perfect. The first response was estate taxes. These are taxes that can be owed when you die. They tax you all your life, and then they get you when you go, if you don't plan carefully. Great answer, and to thank you for that great answer, get a little shopping bag from our firm. All right. That's one, estate taxes. Anybody have any other ideas what people might be trying to protect against? In the back, yes.
Cost of health care, nursing homes.
Cost of health care and nursing homes. Great response. I'm going to pass back to my friends in the front row here a carry bag for you to go shopping with. Yeah, absolutely. People are concerned and trying to protect against the cost of health care and potential nursing home costs for folks, particularly if they're seniors. So we've got estate taxes, we've got health care and nursing costs. Can anybody think of anything else? Yes. Loss of assets, lawsuits, liability. Liability. What if you were in a car accident and got sued? So when I think about asset protection, I'm thinking really about those three areas. We've got the liability, long-term care, health care, nursing costs, and estate taxes. So if we start with liability, I just want to give you a sense of that, because sometimes people come to me and think that they have no liability risks whatsoever. And I say, well, what if you were in your car driving and, God forbid, you hit somebody? Well, they say, geez, Patrick, I've got car insurance. It's going to cover me. But very often, the insurance coverage they have is very low. Maybe it's $50,000, maybe it's $100,000. I think all of us know that when you hit someone in a car and they get a lawyer, they're not going to sue you for $10,000. They sue for hundreds of thousands or millions of dollars. So keeping your car insurance limits low can expose you to liability. Any judgment above your insurance limits can expose your assets. We're going to talk about how we can protect against that. The next one, long-term care costs, health costs, nursing costs. Until families are faced with this, very few people know what the true costs could be. And for many folks, it's astounding to learn how expensive it can be. Not everybody will end up in a nursing home long term. That much we know is true. But the risk exists for many of us that it could happen. Nearly half of seniors over the age of 65 will spend some time in a nursing home. Hopefully for them, it'll be a short-term rehab stay. But for many folks, it's long-term care. There's a U.S. government Centers for Disease Control. They did a national survey earlier in the decade and found that the average duration of the long-term nursing home stays was 838 days. That's a long time. And when you factor it in that we live in Massachusetts, one of the costliest health delivery states in the country, probably one of the better ones, certainly, but one of the costliest, that's a lot of money. There are nursing homes locally that are charging over $400 a day. In fact, some are $425 a day. And that's for a shared room. And if you multiply 838 days times $425, you're talking north of $350,000. That's a tremendous amount of money, and that's a concern for many folks in trying to protect their assets. Imagine what that could do to your savings or to the equity in your home. And those are in today's dollars. We know that those costs are not going to decrease in the future. If anything, they increase greater than the rate of inflation. Sometimes clients say, well, can't someone else pick up these costs for me? Some folks, very few, have private long-term care insurance. But oftentimes, by the time seniors might think about it, based on their age or their health, they might not qualify, or the premiums might be so high. It's a great product if you can afford it and you're in good health in your 50s, 60s, maybe 70s, but for many people it may not be an option. Even the best policies might pay a couple $100s a day. So when you're talking about nursing costs costing over $400, the best policies might not cover all that anyway. I've had arguments with folks who have said, Patrick, I have Blue Cross Blue Shield insurance and they're going to cover me. And I say, no, you have a medical insurance. That doesn't provide long-term care coverage. And sometimes it takes a while for that to sink in, but it simply does not. Others say, well, Patrick, I have Medicare. Medicare is going to take care of me. And it's true. Everyone, when they reach 65, you qualify for Medicare. But Medicare pays for short-term rehab in a nursing facility in certain instances where the individual might qualify. And that short-term rehab can be anything from a few days up to 100 days. So Medicare is great, but it's also not something we can rely on for long-term risks. The last one is Medicaid. Medicaid. And in Massachusetts, Medicaid goes by the term Mass Health. So you might hear me use those terms interchangeably today. It's the same program. And Medicaid is a program that can pay long-term care costs if you qualify. And as a general rule of thumb, they require that you have countable assets of under $2,000, truly impoverished. And if there's a spouse at home, the spouse can keep up to about $110,000. Those are really tough numbers for a lot of folks. And so planning for those risks and those concerns is important. So we've addressed liability, what the issues are there. We've addressed the health and long-term care costs. The last one I want to touch on is estate taxes. And then we're going to start talking about some solutions, okay? So estate taxes. Estate taxes are on anything over $1 million. So there's many folks who, when they die, they don't have more than $1 million, and it does not apply to them. But there are folks who die with $1 million, whether that's real estate, investments, retirement account values, even their life insurance policies. The value of those when they die, all of that's part of their estate. And you can understand why. The IRS wants to count everything to maximize the number of folks who might fall in that threshold. And those laws have been shifting. Massachusetts has been set. It's $1 million. That's been set for the last decade, and I don't expect it to change anytime soon. The federal government says that if you die today, they won't tax you on anything under $5 million. That's great. But on January 1st of 2013, if Congress doesn't do something, that number is going to drop down to $1 million with a tax rate of 55%. And given that Congress can't seem to agree on what the weather is outside, it's a bit disheartening to think, are they going to be able to agree on something as challenging as estate taxes in the next year? So again, that is a consideration for folks who might have $1 million or more when they die. So that's the kind of the bad news. Let's turn to the good news. What can we do about this? I'm going to start with some easier strategies, and then we'll move into some more complex strategies. The first one, I'm going to go back to liability, auto insurance. So many folks have auto insurance with very low liability limits, $50,000, maybe $100,000. I tell people, look, if you have assets to protect, a house, savings, retirement accounts, you really should consider increasing your auto liability limits up to the maximum, which is usually $250,000 per person or $500,000 per accident. I say 250/500, and I think that's on the outline I gave you with the presentation today. Now, you might think, well, geez, that's going to cost a lot of money, increasing my premiums. But the truth of the matter is your premium is mostly based on your age, your gender, and your zip code. And you might find that when you talk to your auto insurance agency, that the premium increase is fairly mild given the level of protection you get with an increased coverage.
The other thing when it comes to liability and insurance, there's a product called umbrella liability insurance. And this is a policy that you can buy. You have to have the max limits on your auto first, and then you're eligible to buy this umbrella policy. Usually we think of the umbrella in terms of $1 million of additional liability coverage. Now this may not be for everybody, but if you own a property or maybe a multifamily or you've got significant savings, having an extra $1 million of liability coverage can be great. Because if someone's cleaning your gutters and falls and gets hurt and sues you, you might have some homeowners coverage, but again, there's limits to these policies. So the way the liability, the umbrella policy works is once your auto or your homeowners has paid their max coverage, then the umbrella opens up for an additional $1 million of coverage. And that can help preserve and protect your assets against a lawsuit judgment. Yes, I have a question in the back.
You do. Shouldn't that workers be insured if it's doing work on your home?
So the question, and I'm going to repeat questions today because we've got folks viewing at home. The question is, shouldn't that worker be insured? They're doing work at your home. Well, there's, I guess, two ways to look at it. Should they have their own insurance? Absolutely, they should have their own insurance. But the reality is, we're in a terrible recession, and many folks are going without any kind of insurance, whether it's health insurance, liability, work comp, anything. And then with regard to your own homeowner's coverage, it may have some coverage to help protect you against someone getting hurt on your property. But there's limits to that policy. And you'd want to talk to your homeowner's insurance agency about that. So when you have folks work on your home, I always encourage clients that they request a certificate of coverage from the worker that shows what their insurance coverage is. And they should have their insurance agency fax it right over to you. So that can help ensure that they actually have some coverage. But in the world of injury and lawsuits, there are never any guarantees. When people get hurt, they sue everybody, and the more insurance you can have, if you've got things to protect, the better off usually you're going to be. Good question. Next topic, homestead declaration. Now, that's a fancy term. And we've had this homestead statute in Massachusetts for decades, and it's varied over the years. But in March of this year, the legislature enacted a really completely new statute, really overhauled the statute. And the homestead statute says, look, if you own a primary residence in Massachusetts, and you live there as your primary residence, you can record a homestead declaration at the Registry of Deeds. And that homestead declaration will protect you and spouse or any dependents living in the home against someone, a creditor, a judgment creditor, for up to $500,000 of equity in your home. And if you're both over the age of 62, you'd have $1 million of protection because you can stack the protection. The new law says if you own your home in trust, for the first time ever, the legislature says that the trustees can also record this homestead to ensure that you are protected. So that's a great feature for folks who own real estate in trust. I strongly advise that clients have a homestead protection in place if they have a primary residence. There's a lot of uncertainties with regard to the old law. What if you refinance? Did you lose the protection? Did I do it right? What I've told people is you want to talk with a qualified elder law attorney or estate planning attorney to review whatever you have in place if you have any doubts whether you're covered, because this has to be done very carefully to get it done right, and you want to be certain that's in place. One point about homestead declaration, it does not protect you against Medicaid or nursing home costs. So the government was smart there. It said, wait a second, we're going to give you a lot of coverage, for lawsuits and things like this. But if you end up in a nursing home, homestead doesn't do anything to protect you. You have to look to other strategies for protection there. Now let's move into another topic that concerns me about folks of all ages, young, old, and in between. And that is, if you haven't done planning and you have a health crisis and get sick and become incapacitated, you're unable to make decisions for a period of time regarding your health or your finances, that can be a real challenge and a tremendous cost and stress to you and your family. So we're going to start by asking about the words guardianship and conservatorship. Can someone tell me what a guardianship is? Any ideas? I see an honest answer in the back, someone shaking their head no, or maybe they're swallowing the brownie they've just eaten. But, you know, these are tricky words. And what it means is that if you can't make healthcare decisions and you have not done estate planning in advance, your loved ones, your family, have to go down to the probate court, hire a lawyer, and go through a guardianship petition at the probate court. And a court eventually will appoint a guardian to make healthcare decisions for you. When it comes to financial decisions, we call it a conservatorship. Now, the person who's the guardian might be the conservator as well. It doesn't have to be different people, but their roles are distinct. I have clients say, Patrick, that doesn't make any sense because I'm married. My spouse is going to make the decisions. Or they say, well, look, my daughter, she's a nurse, she'll make the decisions. We don't need a guardianship or conservatorship. Well, that's wrong, because the hospital is not going to listen to anybody else, because they would be liable for listening to anybody else. You can't take away someone else's decisions without very specific authority from the court. So you have to have either estate planning in place in advance, or you end up in the probate court. And I can assure you, as much as I respect and work in the probate court, you don't want to be in the probate court if you can avoid it. Because as soon as you use the word court, it involves a lot of filing fees, attorney's fees, time, stress, and uncertainty. And it's a great invasion of your own privacy. Everything about you now is public in the courtroom. You know, and I'll tell you a quick story about conservatorship. I had a client just in the last few months. They had come in a couple of years ago, and I explained the importance of doing estate planning to appoint somebody to make these types of decisions if you got sick, so that your family doesn't need to go to court. They took my advice under advisement, and they procrastinated. I remember I warned you about procrastination. And lo and behold, she had a health crisis and became unable to make decisions. And I have had to help that family through a deeply complex probate, guardianship, and conservatorship, because she ended up in a nursing home. So not only did we have to get decision making, we wanted to be able to protect her assets. And to do that, you have to ask for all kinds of special authority from the court. And now you're at the mercy of the court. Does the judge think it's fair that you should be able to protect your assets? There's a lot of uncertainty. You don't want the judge making that decision. You want to make that well in advance. In that case, the judge appointed a guardian ad litem, somebody who's a professional who actually investigates the situation, reports back to the court. The guardian ad litem's fees in that case, those fees alone were almost $4,000. The attorney's fees, when you add all this up with the filing fees, $10,000, $15,000 or more, is not unreasonable to expect that if you don't do planning in advance, guardianship and conservatorship. This is not just for seniors. This is folks of any age. If you're 35 and you don't have planning in place, and God forbid there's an accident and someone can't make decisions, you end up in court. And once a guardian or conservator is appointed, you have to account to the court every year for what you're doing and go back for special authority. And all of that costs more money. So you want to avoid guardianship and conservatorship. You can avoid conservatorship with a carefully drafted, durable power of attorney. A power of attorney. And this document appoints somebody to make decisions if you get sick. The power of attorney is essential because things can happen where you need to make decisions quickly. For instance, many folks own property together, husband and wife. If one spouse gets sick, you can't take the sick spouse's name off of a real estate deed if you don't have the authority to do it. And timing can be so crucial. So you need to be sure you've got that power of attorney in place now, so that if something happens in the future, you can use it straight away to try to preserve and protect what you have. I have to warn you, all powers of attorney are not created equally. I have clients come to me and say, Patrick, look, I've got a power of attorney. It's a 1 or 2 page simple document, often drafted by a general practitioner who doesn't really practice in the area of asset protection and Medicaid type planning. They didn't mean any harm to the client, but the power of attorney is insufficient to achieve the goals of the family. Because in Massachusetts, you have to specifically delineate all of the authority in that document. So when I'm drafting these for clients, these powers of attorney can end up over 20 pages long. I want to be certain that that family can use every available lawful strategy to preserve and protect their assets and to achieve their goals, even if one of them's in a crisis. And so when we have this inadequate power of attorney, we are forced with tough decisions. We can end up back in court trying to reform or amend the power of attorney, and that's a very expensive, long process, or we can end up trying to seek a conservatorship. You don't want to be in that situation. You want to have it done right. So if you have a power of attorney today and you've got any concerns as to whether it in fact includes all the authority that you need, you'll want to make sure you run those through a qualified elder law attorney, those questions. I'll touch on long-term care insurance because I spoke about it a little bit earlier. For the right people who have got the assets and the income and can afford it and have decent health and based on their age and their premiums, it can be a great product. But for many, many people, I've found that it hasn't been the right fit because they might not qualify or the premiums are simply higher than they're able to afford. I encourage you to certainly to speak to an insurance advisor about the options so that you can consider it in your own planning, and you might get the advice of your own qualified elder law attorney in connection with that planning to see whether that might be a part of the picture. I want to turn to trusts. Trusts. Kind of a simple word, but very complex area of law. There are a couple of different types of trusts out there, and one of them is called a revocable trust, sometimes pronounced revocable, and the other is irrevocable or irrevocable. And as a general matter, a revocable trust means you can create it and you can revoke it. That means you can amend it, revoke it at any time. Most people have a revocable trust, and if it's drafted correctly and it's funded correctly, it can help you avoid probate so that when you die, your family doesn't have to go down to the probate court. It can also achieve other objectives. It can help protect money for minor children or special needs beneficiaries, or it can help avoid estate taxes. But it does not protect you against Medicaid or nursing home costs. And I've had many clients come to me and say, Patrick, I have a trust, I'm protected already. And I look at the trust first or second page and it says, I have all access to income and principal, which effectively is everything in the trust, during my lifetime. If you have all that access and you get sick, the nursing home and Medicaid have the same access. So I'm not here to tell you that a revocable trust is bad. We use them every day. They can be a great part of the plan, but they don't have automatic protection against Medicaid. The type of trust that can do that is called an irrevocable trust. You establish it, but once you establish it, you cannot amend and revoke it. So if you did get sick, Medicaid can't step into your shoes and say, hey, give us everything that's in that trust. Now, this has to be drafted very, very carefully because the laws and the Medicaid regulations are extraordinarily complex. And if the irrevocable trust is drafted inadequately, you might find that your assets are not protected, that the court or Medicaid breaks through the trust. So you want to be sure when you're working with a lawyer that this attorney is practicing with Medicaid and asset protection every day because they're going to know what's necessary to be in that trust to be effective. This irrevocable trust, it does not mean that you have no powers whatsoever, and you may still retain certain powers in the trust that may give you some measure of comfort in using this as a planning tool. But at its essence, the irrevocable trust says that you're putting some distance between something you own by putting it into this irrevocable trust. And many clients look at that as an opportunity to plan for their primary residence, because for many folks, that's their most valuable asset. And there can be some great benefits to an irrevocable trust plan. One of the challenges is that when you use that trust, there's a 5-year look-back period. So that if you did get sick and require nursing care, Medicaid goes back 5 years to examine all financial transactions, all transfers of real estate or any other assets you've made. And if you've transferred something into an irrevocable trust, that's going to be an issue for Medicaid. And so we have to think very carefully about that when we're doing planning with clients. What other assets do they have? We never load up everything into the irrevocable trust because people need money to live on. And we also want to be mindful of that 5-year period. On the subject of this asset protection, sometimes clients say, well, why don't I just give it all away? I'll give it to my kids or my niece and nephew. I caution you against that, or just adding names to real estate deeds. One of the big problems with giving things away or joint ownership, there can be tax consequences, particularly for real estate, really tough capital gains consequences. If you give away a house to a child, very, very costly tax-wise for that child because they get your tax basis in the property. And if you bought the house for $25,000 and it's worth $400,000 today, and your child goes to sell it, they have to pay taxes starting from $25,000 up to what they paid for it. So I caution against gifting for the tax purposes. I also caution because you never know what's going to happen with a house. You might find that the child or nephew says, look, we'll take care of you, Mom and Dad, or we'll take care of you, Nana and Pops. But all of you have heard stories, and I've seen them firsthand. You know, grandfather gives it away, and the next week the grandson says, guess what, Pops? You're out. I'm evicting you. I mean, it's too difficult to really believe, but I urge you to believe it because it can happen. Yes? Well, the question is, how much can you gift to a child before you're taxed on it? Well, I'll warn you, first of all, I'm not a CPA, I'm not an accountant, but I can tell you as a general matter, and you'll want to verify this with your accountant. The law today says that you can gift $13,000 per person per year without having to file a gift tax return, and the recipient does not have to pay income taxes on it because they didn't earn it. That's the IRS rules. But for Medicaid purposes, Medicaid doesn't give a darn what the IRS says. If you give away $13,000 and you apply for Medicaid within 5 years, they're going to have something to say about it, and they're going to disqualify you for benefits. So gifting has to be done very cautiously. Another risk to gifting, we were talking about the nephew or the grandson kicking grandparents out of their own home. You might say, no, that would never happen. I trust my kids. They love me. Of course they do. What happens, though, if that child gets in a car accident and gets sued? Or they have creditor issues? Or they get divorced, and your daughter-in-law suddenly says, I'm taking it. You might find that your house or your bank account is no longer yours, and you can go and shed all the tears you want to the judge. The judge is going to say, well, you gave it away. You don't control it. So I really caution you, that's not a great way to plan, and a qualified elder law attorney is going to talk to you about other strategies that can achieve your goals without those risks. Let's talk about probate. Oh, we got a couple questions. Go ahead.
If you have a irrevocable trust that's 6 years old, and then you put some new assets into it, do they have to wait the 5 years?
The question is, if you have an irrevocable trust and 6 years have gone by since you put some assets in it, let's assume it's an adequate trust, it's working, it does what it's supposed to do, and then you put new assets in it, that starts a new 5-year clock for those assets. Any other question?
If you put your home in trust, either revocable or irrevocable, do you lose the tax benefits if you sell it?
So if you put your home in trust, revocable or irrevocable, do you lose the tax benefits if you sell it? A quick answer is not. You should not lose those benefits so long as you're working with an expert attorney who knows what they're doing. Those benefits can be preserved if the trust is drafted correctly. If the trust is drafted incorrectly, then yes, you could end up losing those benefits. And one of the benefits, of course, if you go to sell it, you want to step up into, the $250,000 exclusion on capital gains. If you die, you want to step up in basis for your beneficiaries of your estate. So there's great tax benefits that you'll want to preserve, and that's why you have to draft these so carefully. Yes?
The irrevocable trust provides a lot of protection. Is there any way you can get out of it if you want to, some way down the road?
Well, the question is, the irrevocable trust has a lot of protection. Is there any way you can get out of it down the road? And the short answer is no. You, as the person who created it and put something in it, really can't say, give it back, I want to take it back. But the trust can be drafted in certain ways where the trustee may have certain authority, not to give it straight back to you, but there may be planning options there that you'd want to discuss carefully with your attorney. What are the options? Is there any possibilities here? But I caution folks, when you use an irrevocable trust, you're giving it away. It's not yours anymore. But it's a long answer and it's complex to really get at the potential issues there. So, yes, why use a revocable trust? You have control over what you own. So you might put something you own, bank accounts, real estate in your revocable trust. You've got full control over it. If you become incapacitated, there's a successor trustee automatically named who steps in to manage these finances for you. It offers the benefit that when you die, those assets do not have to go through probate to reach the beneficiaries. And we're going to touch on probate in a moment. Those assets, if you were above the $1 million threshold, that trust can be drafted in such a way so that estate taxes are eliminated. You might save tens or hundreds of thousands of dollars on estate taxes. If a beneficiary was a minor under the age of 18, or actually you can set it in the trust however you like, maybe under 25, the trustee can manage the property for the minor. There's a whole host of reasons why revocable trust planning is excellent. And it's a really strong part of an estate plan. But for folks, an irrevocable trust is usually really focused on seniors. So it's not something used in the 30s, 40s, 50s as much. Very rarely, I would say. But once you get into 60s, 70s, 80s, it's definitely something that's a lot more concern. It's more limited. Again, you're putting a distance between something you own and yourself. But there is a balance to it, and there's a reason to use both in the right situations. When it comes to probate, anybody have any ideas what is probate? Well, I'm glad you all came today, because that makes me the expert. Probate, when you die, probate is the process where your family goes down to the probate court so that your assets can pass to your beneficiaries. If you have a will, you still have to go through probate. Many folks think, well, geez, I have a will. I don't need probate. No, you do need probate. If you have a trust and everything's in your trust, you might avoid probate. But if you just have a will, you still have to go through probate. If you don't have a will, then the legislature has rules on what happens with your money, and they make the decision. I always tease my clients, they might rename the Tobin Bridge after you, and they're going to repave the Tobin Bridge with your money. The rules aren't quite that harsh, but you're putting your faith in the legislature to make sure as to where your money goes. I always tell people, you really need your own planning. You decide where it goes. Now, probate's that process. You go down to court. And under the current law, it takes at least 1 year. It's rather expensive because, again, it involves lawyers and publishing fees and attorneys' fees and filing fees. The law in probate is going to change in 2012. And that raises a lot of uncertainty because even the courts aren't 100% certain how smoothly this is going to flow. The essence of the law is that for very simple estates, the goal is that under the new law, probate will become cheaper and more efficient and faster. But for more complex estates or anything where there's any conflicts, probate can continue to be a very dragged out, extensive process. So it's hard for me to predict which families where everything's going to be simple and easy. And so for that reason, I often advise if people want to avoid the risk of the unknown in the probate court, it can still be very valuable to avoid probate. Despite the fact that the hope is the law is going to make it at least simpler for some people in the future. A quick point on probate as well. Many people have what I call simple wills. I love you wills. If I die, everything passes to my spouse. That's beautiful. It really is. And I don't say that facetiously. I just had my 3rd wedding anniversary, so I'm a big fan of marriage. And I work with many folks who've been married a lot longer than me, so I'm always deeply impressed and respectful of marriage. The challenge is, while that type of will can be great when you're young, if you're now in your 70s or 60s or 80s and you're concerned about health, or maybe one of you already is in poor health or has a chronic health situation, or maybe one of you is in a nursing home, it doesn't make any sense for the spouse to say, well, if I die, everything goes to my spouse, because that puts everything in their pocket, and all of that is a countable asset if they require this expensive care that was mentioned in the back, this nursing home care. And there's much better planning techniques we can use to address that scenario. So in I Love You Will, instead what we would say is, if when I die my spouse survives me, so my spouse is alive, then I want what's in my name to go into a special trust to be protected for my surviving spouse. And it would name a trustee to use those funds to supplement the care for my spouse, but not to jeopardize any benefits they might be receiving or might be eligible for in the future. Doesn't that sound like a better solution? And these are the careful things you need to think about, and that's why when you're choosing attorneys to work with, you want to work with a qualified elder law attorney who's doing this every day, who knows the ins and outs of all of these strategies. Because the government has not made this easy to do. And that's why most people have no protection. And many people lose their shirts if they get sick or sometimes upon their death. And there's so much that can be done in advance with planning. A few more points. Beware of relying on non-expert advice. With all due respect to the neighbor, the auto mechanic, the postal delivery carrier, the airline steward, bank teller, when it comes to these types of issues, you need to rely on an expert attorney, not on somebody who doesn't practice in this area. And be especially aware of relying on your friends and family who say, well, geez, Uncle Joey did it this way back in '95. Well, sure, 15 years ago, the laws were very different. If you do what Uncle Joey did, you might find yourself in a real pickle. Or what your cousin Eddie does down in Texas. The laws in every state are different, and everybody's circumstances are different. So you really have to be sure you're looking at it from your situation, getting expert advice for you, so that you can make an informed decision. And I respect any decision that you make as long as you know the facts, and then you decide what your goals are and what you want to do with that. We've talked about gifting and the dangers of gifting, or jointly owning assets, just putting the kid's name on everything. Well, both of those are real challenges. Another downside or myth is believing it's too late to do anything. Geez, Patrick, I'm already 82, it's too late to do anything. No, it's not. It's never too late to do planning. I do a lot of advanced planning. I do a lot of crises planning. I help folks who are already in the nursing home. Sometimes they've already paid $100,000 to the nursing home, and then somebody gets the smart idea, why don't we ask an elder law attorney? What are the options? So it's never too late to do planning. What I tell you is that you can accomplish more by planning early than you can by planning in a crisis. And so for those of you who are here today, I encourage you to plan early. You're here, you're interested, it makes sense. For those at home, I encourage the same thing. But some of you may find yourselves, you're already in crises or near crises. At least find out what your options are so that you can make an informed choice. Another point on gifting. I have clients say, geez, Patrick, I haven't made any gifts. And I say, well, tell me about that condo. It looks like you sold it to your daughter. They say, yep, I sold it. I didn't give it away. How much did you sell the condo for? $100,000. Great. And what was the assessed value of the condo? Well, $325,000. And I say, well, guess what? The IRS and Medicaid considers that you have now made a gift of the difference between what it's worth, $325,000, and what you sold it for, $100,000. So you've made a gift of $225,000. And they had trouble believing me, but that's the way it is. So be very careful. Gifts can happen sometimes without you knowing it. I've touched on this already. I'll just repeat it. If you have a spouse who's already in the hospital or in rehab or in a nursing home, the spouse that's healthy or at home, you want to be sure if they have that spouse named on their IRAs and 401ks and all the bank accounts in the house, and then the quote-unquote healthy spouse dies, everything ends up in the sick spouse's name. And that's such an unnecessary position that you put that spouse in, because now everything's a countable asset to them, and they may lose a lot of that without quick, careful planning. So I really encourage people in that crisis, as much as you're looking at, geez, we're just trying to focus on getting the care we need, you can't forget the legal element. You got to start thinking and planning. All right, I'm going to conclude by bringing this together. We've talked about finding an expert. And remember in the handout, I've got 10 questions to help you locate qualified estate planning and elder law attorney. Taking action. Procrastination doesn't give you any protection. And lastly, make an investment. This isn't simple or easy. As you can see from the hour we've spent talking today, this is complex stuff. You need to work with an expert, and you need to make an investment to make it right and do it right. And so with that, I want to thank you all for coming today, and I'm going to open this up now to question and answers. Yes? The question is, how frequently should legal documents be reviewed? And that's a very tough question, because many people would like to just do it once and never look at it again. The challenge is that the laws do change over time. We've talked today just about the Homestead Declaration law changing, guardianship, conservatorship law has just changed, probate law has changed, Medicaid laws have changed quite a bit in the last few years. I tell people, certainly the older you get, the more often that you want to touch base with your attorney. It may be as often as every 2 or 3 years, but certainly not more than 5 years, because things change and people's lives change. They may have named somebody in their power of attorney who may not be available to assist them now. Maybe they need to update that. or their own assets have changed. Maybe now they have an estate tax issue, or the spouse has been diagnosed with Parkinson's disease, and now their goals have changed. So it's certainly something you cannot just set it and forget it. You really need to have an open dialogue with your attorney to make sure that you have that ongoing protection. So if there were two people named on a homestead declaration and one passes away, as a general rule of thumb, that protection continues for the survivor, okay? So it continues for the survivor. It usually would not require that you record anything new with regard to the homestead. But every case, I caution you, I'm not able to give legal advice about individual situations because the attorney would want to very carefully review the homestead, the book and page, review the facts. But as a general rule of thumb, if both have been named, that benefit continues on for the benefit of the survivor. How does someone keep up with all these law changes? How is a senior supposed to know these changes in the law? There's no easy answer for that. One is you watch the news. You hope you're working with an attorney who is going to have an open, ongoing dialogue with you. I write to my clients. And in fact, I'm in the process of doing that now. I do what we call an audit. I go back, all those clients who did certain types of planning, I write to them about the changes in the homestead declaration. Many attorneys just don't have the staff to do that. But so some of this can fall on your shoulders to follow up with your attorney to say, well, have there been big changes that I need to be aware of? Now, the probate laws themselves, it doesn't mean that your will is no good or it invalidates your will. It just means that when you go through probate, the process is going to be different next year. The question is, if you add your children's names to your assets, or you give away your assets to your children, and your children are sued, could you lose those assets? And the answer is yes, your assets can be exposed. Because when someone is suing, they are going for broke. I mean, you watch the TV shows, they sue everybody and they want to take what they can. So there are risks to that. Now, if you tell me, geez, I've owned it that way for many years, you want to talk to an attorney before you change anything. Because maybe you've had your kids on your deed for 15 years. You'll want to talk to an attorney. There may be certain advantages to leaving that in place depending on your health and your age today. Because there's consequences to taking people off of real estate or accounts and consequences of putting them on. And that's why before you make these big decisions, you want to say, wait a second, I want to talk to the qualified elder law attorney to be sure I'm doing this right and I'm making an informed decision. Any other questions? Yes? Yeah, the question is POD, payable on death account at a bank. Yes, you can name a child as a beneficiary that way, and it should avoid probate because it says where it goes when you die. It's fairly limited, so it might be ideal for clients who have very small bank accounts or just want to be sure that one certain account might go that way. It doesn't protect the account against Medicaid or anything like that. But a payable on death account, that's different. If the person's named, if a child's named on that account and the child gets divorced, your account's not at risk because they don't own it. They only get it when you die. And you could change that account while you're alive. There was another question, yes?
If you get a homestead declaration, does it have to be renewed because of the changes that happen?
Generally, the question is, if you have already a pre-existing homestead declaration, do you have to renew it with this new law? Usually the answer is no. The law was designed to preserve existing homesteads that are in force. I say that with some caution because there's so much complexity to the old law that maybe your old homestead isn't even effective today because of something you did with the deed, the chain of title. So if you have any questions about it, you may want to have an attorney take a look at it just to say, yes, you're okay. Any other questions? Yes. The question is, if you had a will from many years ago and the attorney's passed away or moved on, and then the person dies, well, and maybe that attorney was holding your will, where is it? That comes up, and you'll sometimes see advertisements in the paper, and we're trying to find these files. It can be tricky, and so you definitely want to keep a good sense of where your will is. My practice today is that clients hold on to their own original documents and their original wills, because over time, you just don't want to be in that position. I'd rather have the client hold on to it.
So they're not filed in the probate court?
No, yeah, generally, no, they're not. Generally, no, they're not going to be just, lawyers aren't going to file them all at the probate court, so it's there when you need it. Yeah. Now, after death, they're filed at the probate court. Any other questions? So they were told that if one spouse were told they were terminally ill, get the terminally ill spouse's name off of everything. And I would tell you potentially the opposite. I would tell you, make sure you're working with a qualified elder law attorney, because they might tell you they've got some very interesting planning that could offer you a number of strategies that might be different. It depends. When someone says they're terminally ill, are they going to potentially die in a couple of months or 10 years? And a couple of months. Okay. In that case, I would say I would have a very different strategy that I would use for that couple, and that might offer long-term asset protection for the surviving spouse. So I would be very cautious about just taking names off, because I have a different strategy I would use. So I'm being warned we have 1 minute left. I'm going to say thank you. These were excellent questions. And I appreciate it. And I'll just remind you, more information is on the website, curleylawfirm.com. Thank you.